Okay. Let me go over this thing here. So basically, we got an individual that lawyered up and just think that you could just file a whole bunch of nonsense and it flies. It don't. A lie is a lie. So you just sent me the one email?
Well, I actually I sent two.
Yeah, okay.
The first email was a list of everything that was wrong, and like I was telling you yesterday, even after I sent that email, I still saw some more stuff that wasn't critical, but
yeah, I got you.
Listen, I already know it's a lot, so I'll just send this email. The second email was I emailed the principal like you told me to do also.
Ooh.
And of course I got a BS response from him.
Oh.
So I sent you the email that I sent to the principal, and then I sent his response. But then I responded to that email. That was the only thing I didn't send you yet. But I could basically sum that up for you. It was real short.
Yeah.
Basically what he said was, now he's backpedaling a little bit, but I could tell because it took him 24 hours to respond to that email.
Well,
so I'm pretty sure he contacted the mother and her attorney.
Well, let's be here. Let's be clear. We want him to backpedal, but go ahead.
Right. What he said was, "Oh, it's not." Now he basically what he's saying is that I wasn't being hostile. He was just saying that he was saying, "Oh, the email that you sent the staff earlier in the year made them uncomfortable."
Oh, so we want to be clear. The email made them uncomfortable because in the email you was yelling in the email. Is that what they're saying?
That's what I'm trying to figure out. So I sent them a very simple response. I said, again, them being uncomfortable is in no way the standard for me being hostile. There's a very obvious difference, right? Again, I said teachers and staff can be diligent and aware when a child is playing with a pencil, but when a child comes to school repeatedly with visible injuries, the same standard of attention naturally doesn't apply. And is not reported, but playing with the pencil gets reported. Maybe your staff should be uncomfortable with the way a child is sent to school before they're uncomfortable with an email.
Well, listen, I believe we told the school, heads up, there were some claims made that I came near XYZ and you're going to be mentioned in a lawsuit. So once again, what I tell you and what I tell everybody, what women want to do is they can't fight. Women in no way, shape, form, or fashion can fight you. They can't. If they could, they would just step to you in the streets. So what they do is they want to collect everybody that y'all interact with and try to persuade them to be on your side. And in order to get you to look bad, everybody that y'all interact with, she's got to now say, well, they're uncomfortable with this and all that. So we hit them with the, like what we said. Look here, counsel. I'm laughing out loud at your angry black man syndrome. But I tell you what, this is how we're going to do this. You, your client, and the school going to be mentioned in a lawsuit. So I'm trying to tell you, they didn't think you was going to respond like that because no man responds like that. Everybody respond with the perspective and narrative of the court is the boss and I'm just going to always be trying to play tag along. So we said, no. This is not what we do. The angry black man, is that what you're going with? LOL. That's funny. But listen here, counsel, in your motion that you filed, a lot of stuff is missing. Like I said, I went to law school. I can read any type of legal document and tell you if you're going to win, if you're going to lose. I can read the document and say, well, you said this, there's no supporting evidence. And when I read that motion that they filed, it was 100% pure grade A scare tactics. That's all it was. It wasn't backed by nothing. But the thing that really jumped out on me the most was when they said, if you don't show up, a warrant going to be put out for your arrest. That set the tone for you to be scared. That's why we responded in emotion. Did you just threaten me to come to court? LOL. For custody. Oh, okay. Next time you threaten me, next time you send me a letter to come to court, put the key to the building. I'll be the first one there. So when she read that, I promise you, bruh, she sat there and said, damn, we swung, we threw our best pitch at him. He knocked it out the park. They bluffed, you called. So this is where we at. So when you reached out to the school, they said, oh, okay, wow. Yeah, because once again, we said, you need to show me cameras and you need testimony of all the people that are supposedly scared. If that man responded with the staff, that's what he said?
Yeah. Well, he said, cause I don't want to misquote him.
Right. We don't want to misquote him. Because that you should have sent it to one person.
I sent it to him, and because the way they have their school set up, again, because they're not smart enough to be able to communicate individually. They have like an admin that also like can CC on all the emails automatically. Right. This is what he said. He said, I have no context regarding any reports made about you being hostile or volatile.
Woo! Hold on. I don't want you to gloss over that. You just said something real heavy. He said he has no reports of it.
No, he said no context regarding any report.
Right, meaning nobody brought any information to him about it.
Right.
Okay, hold on. Everything he said after that don't mean nothing. It sounds good, but thank you. That's all we wanted. So what he's saying is, please don't come here with that lawsuit. Go ahead. But that's what they basing their case on, right? You went to the school. So if you went to the school and he says somebody lying, from my man, that's why we tell individuals, man, when you put us on retainer, let's start having some fun, because you can read something and you can get mad about it. I promise you, I'm gonna bring the joke around to you. Unfucking believable. Unbelievable. All right, I'm looking for the other email, my man. Oh, there you go. Okay, there you go. All right, so, all right, how many, hold on, let me open up. How many things, okay, line 9, 10, hold on a second. Line 9, 10, 11, 12, 13, 14, 15, 6. Okay, so I'm looking at this and I'm smiling because I'm going to ask you a question. You want to put it all in one motion, or you want to dog walk them? You got us on retainer. You had us on retainer now for about 5 or 6 months. Which way you want to go with this?
Dog walk. I want dog walk.
Oh, my man. Oh, man. Good answer. Oh, snap. All right. So what we're going to do is we're going to pick the first 3, okay?
Okay.
We'll do the first 3, draft that in motion, boom, 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 boom. Then we're going to hit them with another one. Here we're going to dog walk them because we want to help them understand. This individual this attorney that she hired, we want to help them understand. No, I'm going to show you how we do things. Like the average guy, we ain't going to go there. She did this and did on this thing. She did that. No. Everything she did, we're going to dog walk them. So let me get this thing drafted up.
Right, because here's the other thing, because this is what they did last time, right?
Mm-hmm.
And from learning from my own experience, plus what I picked up, like working with you and listening to your videos.
Mm-hmm.
Because that was the mistake we made last time. We put everything in and tried to do it. Because apparently this judge isn't competent enough that he doesn't know what meaningful means. Now, when you Google the word meaningful, it tells you that that's a word that a child should know by the 3rd grade. So, if a child should have enough confidence to know what meaningful means in the 3rd grade, why does a family court judge not understand what meaningful means? Okay.
Well, here's the deal. Like you said, so what I always say and what I'm going to say again, whenever you have an upside, don't nobody understand nothing. Whenever you have something that's against you, they'll put it in a magnifying glass and put it on a hologram. They'll put it on a billboard in front of the courthouse.
Okay.
So they understand They just got to play dumb because what they're not used to, because no attorneys do this. No attorneys help fathers. Nobody help. I don't know. I'm just saying. I'm saying this because I couldn't find the help when I needed it. Nobody help in the depths like we help. Nobody does this. Nobody nitpick. Best thing to do, we be tit for tat. All these little things, nah, see you in court. No, see you in court. So the family court judge is not used to a father handling things like this is a criminal case. Applying things, pointing out things, catching things, saying, you're not doing that. Especially that nonsense, that Powerball movement she tried to pull, saying the XYZ. That one email that you got from the school, it refutes the whole case.
Right.
You can't say that. It's amazing. But like I said, when I read it, I just said, Dad, she put intimidation on overdrive, starting with if you don't show up, we're going to lock you up. Oh, you know why? Because she sat down there and dressed up this thing and thought she thought she was going to sit you in court and have you pointing to you. And he did that and he did that. Oh, no, we want him here for this. Oh, he did that. He did that. Didn't know you was dealing with a mastermind. Said, no. Let's go talk to these people that you claim. Okay, what they said that so your whole motion need to be thrown out. But I'm going to dog walk you into something else. And that's what it's about. That's why individual no attorneys help their clients like this. They always help them. Yeah, they always help dog walk you to your demise. Okay, now all this was done in motions, the stuff that was filed, correct?
What the stuff that I listed for you?
Yeah.
Yeah, that was in the motion that she filed that I sent you.
Good. Okay. All right. So motion claims that I have increased pattern of hostility, obstruction, and emotional validity. Okay. Volatility. Excuse me. Never gave time. Ooh, very well said, my man. Oh my. All right. So we're gonna do that one. Mother claims that I told the nurse practitioner that I had a custodianship. Okay, lie. And then mother lists an incident, but no proof. All right, we're gonna do those three things. We're gonna put those three things in the first motion. Okay.
Okay.
All right, hold on a second. Let me get this thing drafted up, and then I'll be right with you. They're gonna be like, what? Because men, we don't fight like this. We don't come with all these lies and all this nonsense. And this is how they allow courts to win. This is how they allow women to win. Because men don't know how to refute none of this. You know, they don't. The average man would have got that motion you got and went to court and got his handed to him. And they would have sat down there and said, see, now it's valid because he came in here saying, and this and all that. You said, no. Counsel, there's what we ended it with, there's some information missing from your motion, right? You got to file, if you're going to say all this, I need cameras, I need testimony. You don't got none of that. So what are you going by? All threats. It's typical. It's what family court attorneys do. That's all they do. They don't know nothing else. There's no other narrative of victory for their clients, but then to come up with a lie, a fabricated lie. But when you got all these movable parts, when you start saying lawsuits, people back down quick. Hey, check this out. Tell you a story right quick. Atia LaShawn Bradley had 2 child support cases on me, right? 2. In 2 different cities, 2 different states. One transferred over to one, and then the one that transferred it kept it open. So Atia, for 7 years, I was trying to get her to close the case. I called attorneys. I remember I called this one attorney. Bro, he was giving me, he was like, yeah, no, I understand. They're hitting you on both ends. Yeah, but then he said, well, A case can't be closed unless the mother closes it. That's the riddle. Ain't no mother gonna close it. Not if it's right or wrong. The case can't be closed unless the mother closes it, right? I talked to super nerd genius number 1. I'm super nerd genius number 2. Super nerd genius number 1 is my daddy. Called my pop. I said, Dad, this is what they doing to me. Dad, they got a thing over here and a child support and another. Before I said and another, and I said, and then they got another one. My dad said, sue them. That's just how my dad talked. Same demeanor, I sound just like him. Sue them. I said, who? Sue, hey, listen. Sue the caseworker. Don't sue the county. Sue the caseworker and your child's mom. Sue them for $1 million. I bet they closed the case. I said, okay. He said, yeah, put one as the defendant and one as the, put your child's mom as the defendant and put the caseworker as the co-defendant. Guess what happened 11 days later?
They dropped it?
No, they closed the case. They closed it.
Oh.
I drafted up a motion. I said, Atia LaShawn Bradley is the only woman in history that gave birth to one child, never adopted a child, never obtained one child, but actually have 2 child support cases for the same child born on the same day with the same name, exact same person. She is the only one in history that got 2 child support cases, 2 different amounts, 2 different arrear amounts, 2 different. She's the only one. I'm suing for $5 million for emotional pain and suffering. I would drop this lawsuit if they close the case. What do you think happened? Close the case. When you threaten lawsuit and you know how to package up your lawsuit and do it right and everything, oh, like you said, backpedaling, shoot, man, they put a motor on that thing and turned it backwards. They wasn't pedaling at all. They said, no. We're gonna put a motor on this boat and back this thing up. Motion for perjury. Oh my gosh. Now here's what you got to do. Do you remember in which motions that they gave each one of these things was on?
Yeah, they were all in the same motion.
Oh, good. So what we're going to do is I'm going to put Exhibit A, that motion, and you're going to put all 3 offenses highlighted, okay? Can you remember that? No, I'll put it in there. I'll put it in here. So you want me to submit a copy of her motion as Exhibit A? And then highlight the 3 that we're talking about. Only the 3 we're talking about. Yeah, you have to. You have to do that. Yeah, you have to do that. Okay.
Okay. Submit mother's motion as Exhibit A. Because what she's saying, right, with the line 10, what they're saying is that I got her evaluated. They're trying to say that I hired a nurse practitioner and lied about saying I had custody.
It's right. Listen, ain't nobody that. Do you know who that nurse practitioner is?
Yeah, I have all her information. She was the one. What happened was because she didn't complete the evaluation yet.
Hold on. No, I got you. So. You want to send we got to hit her. We got to bring her in this lawsuit too. I just when you say, yeah, that's all I needed to know, because all these movable parts, we got to reach out to them. Hey, listen, how do you reach out to her? You emailed her?
Well, she called me, but I had the, like, they don't have like individual emails. They have like the email for the main office.
Even better. Hold on. I got you. Even better. You need to send her, just like you sent to the school person. You're going to send them an email and say, listen, $100,000 class action lawsuit is going to be filed and you will be the co-defendant, because what you told this person is you told her that I told you. Okay?
Okay.
I'm going to look into the future right quick. Hold on a second. I'm almost willing the same thing going to happen again.
Right.
All right?
Because now they're claiming that the mother contacted their legal department saying that I don't have custody. No, they said the word they used was guardianship. And I said, I never had guardianship. I never said I had guardianship. Yeah. What I said was I have rights to the child's medical record. So the child was evaluated. I'm not. They said, "Oh, well, you can't sign her up for treatment." I said, I'm not signing her up for treatment. The mother already had her diagnosed. I'm just getting a second opinion.
Right. Hey, listen. You're telling me right now, you said, I never said that, blah, blah, blah. It don't even matter. They said what they filed is wrong. You could have said, I'm the okie dokie man. That's part of how things go. Like for example, I remember I got pulled over. I was down in Florida and I was eating macadamia nuts. And a cop walked up to me in traffic. And I'm like, yeah. He said some of the crumbs of the macadamia nuts was crack. So he was like, this is crack, ain't it? Even if I was joking and said, yeah, I would have went to jail for crack. So what's my point? Whatever you say, you can't back it up. They'll say no, blah, 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 blah. So but in this case, it's a situation of he said, she said, but more so than anything, they're now filing something in court. So now they're saying that you said this. Wording mean everything. You said that you have a right to. They want to say that you lied and said you got custody, as if you was trying to come take the child or something. You was just trying to obtain something. It could have easily been, oh, if you lied about something, somebody could verify something. But everybody want to work with the mother and give the father a hard time.
Right.
Everybody it's all about the mother. It ends now, bro. I don't know if you're going. I'm telling you, when you start going to these places in a couple of months, they're going to start calling you sir. And how was your day? How was my day? It's 6 a.m. It ain't even start yet. You know, that's how it's going to happen. I promise you. Never responded on this day. So you're gonna file it Monday, yeah?
Yeah.
So Monday is the 12th.
On my calendar, yeah, Monday's the 12th.
Freaking frack. Oh, that's why that's doing that.
You know, and now I'm thinking about what you said, right? Mm-hmm. About how when I have the advantage, no one seems to understand anything. But when they want to help the mother, now it's a complete analysis.
It's conservative approach. Yes, right. Stern, right? Mm-hmm. Yep.
I remember what you told me. You said the problem with the way the custody order was written, which is why you had me ask for the 50-50, because it says access.
Right. How about that?
Mm-hmm. Now, okay. So what does access mean?
Right.
What am I accessing? So if I have access to her medical records, can I not access a second opinion? Am I barred from accessing a second opinion?
Right.
Access, right?
Well, let's back it up. What they think that what your child's mom is trying to make it appear as though everything you want to do with your child has to go through the courts. No. Right. If you want to get your child and take your child to go get tested, you ain't got to talk to the courts about that. You don't have to do nothing. They want to make it appear as though everything got to go through them. It don't. If you want to go get your child tested for a bone fracture, for a blood sample, you don't have to ask them. They want to make it appear as though everything is a code red situation. So when you start fathering on your own, they want to pump the brakes. Let mom do that.
Right.
That's how they want it to be.
But then at the same time, not hold the mother accountable for everything that's going wrong with the child.
Well, that's why we're going to ask that she be held in contempt. Right. That's why. The reason why is you got to ask.
Right.
You know, no offense to nobody, but you can't just tell the courts and say, okay, don't do it again. No, you got to say, hey, no, I want her 10 days in prison. I want her this. I want that. That's what we're gonna just start going ham on this chick.
Right.
Because we only doing 3. And then we're gonna file this, and when you go to court for that, then we're gonna file more. We're gonna dog walker. Uh-huh.
Right. And if they're saying I violated the order, why didn't they file a contempt?
Right. Right. Hold on 1 second.
Mm-hmm.
Attached to the motion 300 that highlighted that the petitioner filed. My apologies now for being in full understanding of court process. How do you and her communicate?
Through a parenting app.
Okay. I just want to know. This is why I want to know, because I'm mentioning that all interactions with her are done through a situation where she cannot say I said anything negative to her, so she's recruiting everything around. Is where I'm going. That's what I asked.
Okay. No, what she's referring to in the motion, I forgot which line I put it on, but she's saying that I didn't communicate with her directly. I sent with the principal.
We just discussed that. We just discussed that. You don't have to see. I'm gonna say it again. She doing what every child's mom do. If you get you see the video where the dude got the kid haircut.
Yeah.
And she just went ape shit. So what? He ain't gotta ask you. So,
right.
But we're resolving that by asking 50-50 legal. We're asking for that,
okay.
And this is the roadblock they're putting up.
Right.
Mm-hmm.
No, what I was saying was what she's saying is I sent, and that's what I was saying. Like, remember I was telling you, with the more I read, the worse it gets.
Mm-hmm.
in the original email when I responded to the school, because when they were talking about the incident with her playing with a pencil, I said, well, listen, the mother's drugging the child with psychotropics, so it's possible for her to have erratic behavior.
Mm-hmm.
She put in the motion that I'm claiming that she's drugging the child with psychotropics. Meanwhile, that's exactly what she's doing.
Right.
The medication that she's giving her is a psychotropic. So
right.
You're giving a child a medication and you don't know what it is?
Right. How about that? There you go. Boom, right there. She's not even aware of what's going on and what's being put in her child's body, because it ain't about that. Everything is about getting you.
Right, and it's like, oh, give your child this, we'll give you money, no questions asked.
Right. All interactions done with her recorded. However, all interactions with everyone else, I'm just an angry black man. And like I said, an attorney ain't gonna do this. An attorney ain't gonna do that. We'll go to court and see what the judge say. Shut the fuck up. How old are you?
39.
Okay. All of a sudden, at 39, I'm a menace.
I'll be 40 in 2 months.
My man. I want a clear understanding as to why all my efforts seem to be hitting roadblocks, with attorneys filing angry black man motions. All of a sudden at 39, I'm a menace to society, laughing out loud. You see the pattern? See, they don't want you to be comfortable when you file motions. They want you to file things and be, like it's even. No, it ain't even. We blasting them.
Right.
This ain't even. This is you having a field day with the nonsense.
Right? And that was another problem that I had with the original attorney, right? When the mother took the child out of the country and left her there, and then came back here, when we went to court, they glossed over it, like they didn't even really want to address it.
Right.
And every time I tried to bring it up, they would shut me down.
Right.
Because they knew that was a problem and they didn't want to address it.
And when was that?
That was back in, 2017, 2018?
Oh, okay, I got you.
No, it was 2017, 2018 when we were in court. It happened, she took her out in like 2015, 2016.
Okay.
And that was one of the other things, because I spoke to both nurse practitioners about that, right? Even the one, and I think I mentioned that in one of the lines. I think it was, I mentioned that in line 10. When I mentioned that to both nurse practitioners, even the one that the mother hired she was like, yeah, that could have an effect on her. So I said, well, if it have an effect on her, why isn't it being mentioned in a diagnosis? And then as soon as I said that, now she starts backpedaling. Oh, no, it's not. And what happens is, I guess when the mother's sending these people this document, she's not sending them all the pages. She's just sending the first page that says she has sole custody and legal.
No, I got you. She's always trying to make it appear as though she's the higher and you're the lower. Got you. Because, like I said, that's what they want to do. That's
right. Because she said, because the nurse practitioner told me that she contacted the legal department. I said, well, listen, if they have the paperwork, I need them to contact me so I can tell them what's going on. Now, that was yesterday. They were supposed to call me, never called me.
Right. And at first, she claimed that the motion, she didn't get it, right?
Right.
Because I'm going to put that in there. I don't want to be wrong and they try to get us on it. So I'm going to put that in there. Okay, hold on. I'm ending it with, I want the plaintiff imprisoned for 10 days. I want the plaintiff in counsel.
Yeah, because they gave, I'm going to verify on Monday to make sure they didn't file anything, but that original order that they sent, it gave them to the 25th if they were going to contest the service.
Gotcha.
And they never filed anything. And again, by their standard, I had to be served properly. I wasn't served. Because if they were gonna fight to have the service thrown out, they were supposed to have me served.
Right.
Okay. But that's probably also why she switched attorneys, because the other attorney was the one that said that she was never served.
No, I got you. It was said, so it don't matter. She's wearing it now. Let them sort that out. Let them sort that out.
Okay.
Freak. Can you right quick? Could you look on that motion and tell me what date it was filed? Because I always put the date as the one to look out for. So I'm going to put attached. I'm going to put that.
All right. The summons from the court is dated April 29th, 2025.
Hold on. No, go ahead.
The docket itself that the mother signed and had notarized is dated April 18th.
Nah, I just need the date it was filed with the court. All the other stuff.
Okay, yeah. Okay, the date that it was filed with the court is April 29th, 2025.
Okay.
And
the fuck?
Right, mother switched attorneys, but guess who notarized it?
Who's that?
The other attorney.
Yeah, it don't matter. It's what they got to deal with now. It's like I said, they're gonna fight that out amongst themselves.
Okay.
Like I told you, brother, they're not used to fathers fighting like this.
Now, and these motions that we're gonna file, like while we're doing this to them, like while we're dog walking them, do these all need to be in prior to the 21st?
Nope. You got 2 years. We got 2 years to file this. Nobody can tell you how to fight.
Okay. No, I'm just asking because when I go in there on the 21st.
Oh no, I see what you're saying. Okay. So here's the cool part about that court. Let me tell you the cool part. The cool part about it is this is a separate thing, but this is why I always tell individuals, don't disappear, man. We're gonna file motions like, hey, listen, what I always say. You want to file a motion? I want to file a motion. So what happened is the most beautiful thing in the world is to know you're going to be sitting in court and they're going to say, he filed something else like, oh, we're on a defense. Yeah, you're on a defense. So we want to help them understand. I mean, you going ham, listen, hold on a second. Let me tell you what I learned when I went to school for law. Whenever somebody is hurt, somebody is responsible. Something is responsible. Like they say, lawsuits is all about assigning blame. So if I say my toe got chopped off, I was on an escalator, I was wearing flip-flops, and the escalator chopped my foot off. It's the mall and the elevator, the escalator company is going to be defendant and the co-defendant. Somebody's to blame as to why I don't have a foot no more. And that's what it's all about. If you claim something and know the source of the problem, and the most beautiful thing in the world is to sit down there and watch a woman say, I can't believe my BS is backfiring. Yes, it is. Yes, it is. Yes, it is. Our man went to court. Like I said, April 9th, he went to court. But when they sent all this information. Oh, child support this, child support that, blah, 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 blah. He said, well, she didn't tell you? Had me put out of the house at 11 o'clock at night in November in the cold. I had to sleep outside for a couple of days, right? You know, you're doing her a favor. I promise you that. You're doing her a favor. You're doing her a favor. So it's just, like I said, they ain't used to, somebody going at them like that.
Right. I mean, because I operate heavy machinery at my job. So I'd have to find a workaround.
Right. No, I got you. Hold on a second. The petitioner and opposing counsel are acting like kids playing games under the assumption, well, it's family court. The man always loses, and the mother's act will be glossed over. The mother's act, the mother's foolish acts, the mother's foolish acts will be glossed over. Those days are over. I want the point. Okay. Hold on. So in the way I'm drafting up this motion, I want you to come off like you're the adult. All right?
Okay.
I'm drafting this up. So it's like, you know, when they reading it, they like I said, please remind the plaintiff and opposing counsel, this is a court of law, not a circus. All right? So it's all backfiring on them because they can't say that their actions isn't that. They're women. They're emotional. They have no other way but to act like this. This is standard protocol for them. They're women. They're gonna be bugging out. They're gonna be bugging out when you go to court for this and then we file another one. Damn near the same motion, just incidents is gonna change. Oh my gosh, man. Hey, oh yeah, okay. All right.
Submit the ACS report.
Of
Because
course.
because ACS told me that I needed a subpoena to get the report. She's claiming in her motion that now the scrutiny of ACS has been turned on to me. But they never called me or contacted me ever again ever since the last time I went.
Mm-hmm. Hold on.
They have my phone number.
Mm-hmm. Hold on 1 second. Hold on 1 second. Hold on 1 second.
Mm-hmm.
Bathroom right here. Hold on. Okay, go ahead. What you were saying?
Yeah, she was saying in the motion that she's claiming the ACS investigated her and said, oh, everything's fine, but they're gonna still keep, visiting her. So I'm like, if everything is fine, why are they still visiting? She's claiming that.
She said that in court?
She said that in the motion.
Ooh. But go ahead.
Right? So ACS told me that I need to subpoena the report. So I'm like, how did she get the report if she didn't subpoena it?
She said in the report that she have it?
I don't know if she has it. She said that's just what she said in the motion.
But okay, hold on. So you got to find out if she have the thing. You can't assume. They could have told her that over the phone. So you got to find out if in fact she had the report or not. You got to find that out first. Because I wouldn't want to file nothing and have you looking stupid, man. I want every time.
But that's what I'm asking. I'm trying to ask you how can I find out if she got the report already? Because I guess in order for me to get the report, I would have.
How have you been contacting them?
I don't. I have a phone. I have a couple phone numbers, but I haven't. Ever since the last time I actually physically took her into the building and let them see how she was dressed, and I did all that. I measured the foot in front of them. I haven't spoken to them since.
You remember the name of the person that you took into the building?
Yeah, I got both. I got all three.
Okay, cool. So what we'll do Tuesday. What we'll do Tuesday is just text consultation to Lydia. We'll draft up a letter so you can send it to them.
Okay.
So from now on, when you contact with them, because you can't email them, we'll just do letters. Don't ever call them again.
Okay.
Don't ever call them again. All right. So I'm about to send this to you, man.
Okay.
And I want 50-50 legal custody, like I motioned the court for. Which, yeah, that sounds better. Which they claim. There we go. That's a lot better. I want 50-50 legal custody, like I motioned the court for, which they claimed. Okay.